of the submissions already made. And so far as the central government is concerned, my lord, I know the limited role which the central government would have in facts of the case. Therefore, my lord, the time limit fixed by my predecessor, Mr. Trivedi, for me, my lord, I'll abide by. Lord, kindly have a look at, my lord, just for my satisfaction, section 11.
Yes.
Treating animals cruelly.
Yeah.
Correct, my lord? Lord, my learned senior, my lord, Mr. Sibal has taken your lordship through the entire scheme. But please come to 3. 3 carves out an exception.
Correct.
And series of exceptions are there, my lord. The dehorning of cattle, destruction of stray dogs,
Yeah.
extermination or destruction of any animal, any matter dealt with in chapter 4, or my lord, E. The commission or omission of any act in the course of the destruction or preparation of destruction of any animal as food for mankind, unless such destruction or preparation was accompanied by infliction of, please note, unnecessary pain or suffering. Your lordships were also taken through section 28. Broadly, the act provides for 2 things. A, no cruelty. B, even if there is an act which may involve cruelty, no unnecessary pain or suffering, and the statute, the legislative scheme, goes to the extent of permitting not just cruelty but killing, either for food or for sacrifice or not any other purposes your lordships have seen. So the limited purpose, my lord, within which your lordships may consider exercising judicial review is when the state legislature enacts an enactment carving out yet another exception. Would it per se be repugnant? Because in my respectful submission, even the state would be exercising powers under entry 17 of list 3, concurrent list, and therefore, my lord, I, in my respectful submission, do not think it can be seriously disputed that there is legislative incompetence. The argument at best is both legislatures are competent, but there is some repugnance.
Yeah.
But my respectful submission is, in law, there is no repugnancy at the outset. Because it is only carving out one more exception with the very same condition which the statute stipulates.
Can you see there is no repugnancy?
No, there is no repugnancy would be, my lord. That's something which the parent act says and the state act says something contrary to it. Lord, I'm coming to that. Lord, irreconcilable repugnancy is the only test your lordships have considered to set aside. Ancillary encroachment also is permissible, my lords.
No, but the state amendments,
yes, my lords,
in their own right, they would be repugnant. That is why the assent was sought.
I'm conscious of that. We may not travel into the part whether there is any repugnancy or not. Because there is an assent, my lord, sought and granted.
Correct.
But, my lord, as a proposition.
You're saying even without the assent.
Without assent also, my lord, what they have done is carving out yet another exception to section 11, which, my lord, permits exceptions for more severe things like killing also. Now, my lord, they have done this. Lord, so far as courts are concerned, my lord, your lordships, my lord, are fully aware. Your lordships would not prohibit a particular activity if there is a statutory enactment in place. Your lordships would, my lord, merely examine the constitutionality of that particular provision and hold whether the provision is otherwise incompetent by the, so far as legislative competence is concerned, arbitrary, discriminatory, classification is reasonable, etc., etc. Your lordships would be able to say that no permissible Jallikattu or any race only in absence of a statute. Once the statute is in force, your lordships would examine the validity of the statute. Though we are not, my lord, in the era of, my lord, Vishakha judgment, where there is a vacuum and your lordships are trying to, my lord, fill up the vacuum. Lord, having said that, let me, my lord, first, I'll, my lord, give my written submissions, and I have quoted the paragraphs, and except one or two judgments, my lord, I am not going to read anything. I have quoted relevant parts. But before, my lord, I do that, let me point out, my lord, what is the position in the state of Maharashtra, because there is some distinction. Lord, I fully support the legislation of all three states, Tamil Nadu, Karnataka, and Maharashtra. But in Maharashtra, my lord, I must, my lord, make one thing very, very clear. The impression possibly, my lord, maybe unintentionally, which is communicated on petitioner side, that any bull is picked up and he takes part in either Jallikattu or in race. My lord, nobody has challenged, my lord, and kindly, my lord, allow me to, my lord, develop this a little, my lord, in detail. We have horse races. Any horse doesn't participate in derby or any other race. There is a special breed. The breeding takes place, the training takes place, taking care is a separate care taken, veterinary care is taken, and practice takes place. And that is what, my lord, happens in the state of Maharashtra. The bulls which are participating only in racing, there is no human element.
Bulls are trained. Bulls are being trained.
Lord, there is a separate breed. They are not deployed in agricultural activity or as a transport. Like, my lord, a race running horse will not be in, my lord, a horse carriage.
There is a pleading for that.
Lord, I'll show that. I'll show that.
Pleading is there.
Yes, sir. Pleadings are there. Lord, we in the state of Maharashtra constituted an expert committee, and there is an elaborate, detailed report on this, which we have placed on record at the relevant point of time. What happens is, this special breed, specially trained and protected for that, Lord, they run the race. The general racing arena is 200 to 300 meters, but the law permits maximum 1000 meters. Not more than that.
1 kilometer.
1 kilometer. That's the maximum permissible, but generally the practice is 2 to 400, my lord, I will say, to be on the safer side, which, my lord, is completed within 20 seconds. Because the expert committee says bulls do run. My lord, my lord, my lord, it is sufficiently, my lord, elaborated before your lordships in Nagaraja judgment, my lord, several presumptions, my lord, possibly may not have any factual foundation, that bulls are basically by nature not running, flight and fight, my lord, etc., etc. My lord, there are experts which have gone into. Kindly, my lord, now have, my lord, that expert report. My lord, your lordships would find that in volume 2. My lord, there is a separate volume, my lord.
Take it.
There is a separate volume, my lord, or volume 6.
Convenience compilation.
Lord, can I hand over separately?
Separately, that's better.
Don't take it that I am doing it for the first time. It is already on record. This is only for convenience.
Green.
And my lord, obviously, I will not read the detailed report. I will just point out, my lord, what they have considered and what are the conclusions drawn. Please see, my lord, report on running ability of bulls. My lord, kindly come to the index, the contents, my lord. And 5. Your lordship gets, my lord, the contents.
Yes. Yeah.
5. Bull race, custom and tradition in Maharashtra. They trace it They collect the evidence and they record their findings. Lord, considering, my Lord, the nature of judicial review which my lords would be my Lord, exercising.
Yeah.
Lord, I am not going into the reading of, my Lord, how they have arrived at a conclusion, etc., because that would be something akin to an appellate power, which my lords, my Lord, if your lordship wish, I can take your lordship through, but that may perhaps not be the scope of the present proceedings. Then, my Lord, 6, recognized native breeds of bovine and equine species of India, then types of bull cart races or events in Maharashtra, bull races in other countries, races of other animals, domestication of cattle, comparative anatomy of horse and bull. Look, they've gone into this. These are all, my Lord, experts in the veterinary and their respective zoology field. Stress response and adaptation in animals, comparison of flight and fight response in bulls and horses. Lord, so far your lordships, my Lord, were only informed. Now your lordships have a report of experts on this. Biochemical and physiological adaptation to training, exercise and running. Summary and opinion of the committee. Now your lordships, my Lord, kindly go through. They have gone into in-depth, my Lord, analysis is done. And, my Lord, if your lordship, my Lord, see, my Lord, say, for example, page 20, the draught bull and race bull, they are different. The breed is different. The breeding takes place separately. My Lord, the last year I am told, the best bull of this breed who participates in racing was sold for 31 lakhs. These are not, my Lord, bulls which are employed in agricultural operation or for carriage of goods. They are like race horses. They are used only as race bulls.
Yeah.
Kindly see page 44. Native breeds of bulls in Maharashtra. Lord, all bulls, my Lord, are considered by them. My Lord, I am not going into it. And, my Lord, they decide, my Lord, that this is the category of bull which needs. And your lordships would find page 53. This is the race which takes place. Page 53.
Yeah.
Your lordship has, my Lord, the photograph.
Yeah.
The bulls compete inter se. Lord, why, my Lord, I'm showing this? Lord, Article 48A provides for, I'm sorry, 48, but not 48A. Oh, may I read? I'm sorry, your lordships, my Lord.
No, we have seen it. We have seen it. So actually, there will be two bulls. Actually, they
Two.
run in pairs.
Yes.
Always.
The bulls are generally in pairs.
Generally in pairs.
My Lord, therefore, my Lord, we generally say pair of bullocks. My Lord, in English also, my Lord, we rarely say bullock, pair of bullocks. My Lord, that's
So where does the pain come actually? Which part is the pain actually? So what was identified in Nagaraja as causing pain?
Lord, Nagaraja doesn't unfortunately go into this aspect of the race at all. And, my Lord, I can say this, except the last para which says that Jallikattu and Maharashtra bull race is not permissible. There is no discussion on this. Please, if you don't.
They referred to it. They referred to it.
So they have not, my Lord, the Nagaraja judgment does not locate any pain or inevitable suffering. Lord, if your lordship would like to see para 25 of the Nagaraja, my Lord, judgment.
That's okay.
We have
seen that. We have seen
your
that.
lordships have seen that.
We have seen that.
So, my Lord, thereafter, my Lord, the study takes place in 2018.
Yes.
Whatever was the basis or foundation or lack of it, my Lord, in Nagaraja was removed by the state legislature.
Who you have removed and what is the basis? What
Yes,
did
my
you
Lord, there was an act of parliament, act of the legislature,
Correct.
my Lord, which is, my Lord, similar to Tamil Nadu.
Correct. But then what did you do to remove what was found? That's why we asked you, what is it found painful? In Nagaraja,
The Nagaraja doesn't.
Tamil Nadu, the rules have been completely changed.
Kindly see,
What is the
Nagaraja.
change brought about in Nagaraja?
Can I read Nagaraja page 25? So far as this race is concerned, there is no pain location, location of pain. I'll just allow me to read page 25, para 25. We notice, your lordship,
Yes.
Nagaraja.
Yes.
Can you see para page 570?
Yeah.
14.7.
Page 25. I'm sorry, page 578.
14.7.
14.7.
Some shouting and the like. That's how they say. But no, not pain. We notice in various parts of Maharashtra, your lordships are with me on that. Varied types of bullock cart race are being organized. Bailgada Chariot is a race where no person rides the cart. In such a race, at times bullocks are brought to the venue blindfolded through trucks and let free. Lord, I do not know from where, my lord, the honorable court, my lord, was pleased to, my lord, find this free through a ghat, either side of which spectators, large in number, assemble. Due to sudden exposure to the light after unfolding and huge noise source made by the spectators, bullocks get terrified and run in straight on the slope. But there is no slope, it's on the plain ground, number one. Number two, Lord, the bullocks are trained the way horses are trained. Your lordships have not seen the race, horse races, at least in the television. They are never even distracted, forget terrified. They are not even distracted. They are trained that way. The training takes throughout the year, year after year. And rules band the slope. They are supposed to run on the Medan, the ground. Due to sudden, many of the bullocks are tortured and whipped to make them run, and the price is decided on the basis of time taken to cover gap of approximately 300-meter distance. Races are also there where bullocks have to cover 10 kilometer and more. There is nothing to support this submission. 10 kilometers during the course of race, cruel practices like beating, twisting of tail.
Paragraph 2 of the judgment, because it was directly in issue. Because what happened was that the government of Maharashtra prohibited bullock cart races.
Correct, my lords.
That's how.
Thereafter, my lord, this was.
It is not obiter or anything like it. It is actually directly in issue.
Thereafter, my lord, the basis of that is removed.
It is not obiter.
Yes. I didn't say obiter, my lord, but these are not, my lord, the factual findings arrived at after, my lord, any assistance. I'll put it, my lord, that way.
The government of Maharashtra actually prohibited the bullock cart races.
On these grounds, yes. Para 2, your lordships are right.
Yes.
The 24th of August 2011. But it doesn't say they prohibited on the ground that there is some pain or there is some tail twisting, etc., etc. Now, my lord, even that has gone. Your lordships, my lord, are reading Nagaraja in a separate regime. I don't wish to, my lord, repeat what is already argued. Now, we have a separate regime, validity of which is in question before.
Correct.
Now, my lord, see, my lord, the Act.
6.
Volume 6, my lord.
Let us see the act.
Of the convenience compilation, my lord, volume 6.
We wanted these acts.
Standalone.
It put in my written note, we can read from there.
With all acts, yeah, my lord, I think someone who is common to all can do that.
Yes.
Your lordship wanted the amending acts.
Yes.
But that's already part of the compilation and given your
No,
lordship.
if it is not there, my lord, we will ensure that the compilation is.
Now there are compilations of compilation.
Lord, I've given your lordship a chart with the relevant provisions culled out of all the acts that are given separately. I can supply fresh copies that are given in my service.
Yeah.
No, my lord, there, my learned friend is right, Mr. Luthra is right. There is a my lord, convenience compilation of documents, volume 1.
Apart from this, Mr. Mehta, I've culled out I've given you, we'll get another copy. Just culled out the relevant provisions of each amending act. Along with the chart that was given, I'll give fresh copies. for convenience.
Your lordships have, my lord, this convenience
I will
compilation.
get that.
There, my lord, whoever has compiled this, my lord, but has,
Ye wala.
Compilation has been very painstaking.
yes, my lord. No, they have given, my lord, even
Mr.
notification.
Mehta, it was given like this, but I'd given it in writ petition civil 24.
Anyway, the double compliments, but even the first one was very good.
Mr. Mehta, it's a rare day. I will remember this. and
Yes, yes.
you
So
know,
kindly come to, my lord, page 141 of the convenience compilation. 141. So this is really wider. This encompasses wider.
The bill is there, please be given separately.
I don't have.
Just take it. Baad mein do.
Yes.
Yes, my lord. First, whereas it is expedient to amend the Prevention of Cruelty to Animals Act in its application to the state of Maharashtra for the purpose hereinafter appearing, it is hereby enacted. My lord, kindly turn the page over, my lord, page 2. Bullock cart race is defined. Bullock cart race means an event involving bulls or bullocks to conduct a race, whether tied to cart with the help of wooden yoke or not, by whatever name called, with or without a cartman, with a view to follow tradition and culture on such days and in any district where it is being traditionally held at such places as may be previously approved by the district collector and also known as Belgada Sharia, Chakadi or so and so in the state of Maharashtra. So, my lord, first of all, define. Second, it can be done, my lord, in furtherance of tradition and culture, which is now, my lord, by a report of a committee which is not under dispute, held to be culture and tradition, and places where traditionally it is being held. And fourth, only with the permission of the collector, my lord, and the permission ensures that unnecessarily pain is avoided and the care is taken to ensure that. Now kindly see 3. Notwithstanding anything contained in subsection. I'm sorry, my lord, your lordship.
See, one thing fact we would like to point out is paragraph 29 and 30 of Nagaraja. The state of Maharashtra issued a corrigendum on 12/9/2011 and later on 24/2012 imposed a total prohibition. Now the state of Maharashtra, the High Court actually upheld that ban.
Yes.
Somebody else challenged it.
Yes.
And then paragraph 30, if you read, we have already indicated that Maharashtra has accepted the judgment of the High Court and the decision. So, unlike in Tamil Nadu, where cultural and they were siding always with the people there, the government actually imposed a ban.
But the government, my lord,
So, we are just pointing it out.
yes, my lord, but that's never perennial. my lord.
Mr. Mehta, that's why this paragraph 25 was a statement of fact by the government of Maharashtra before the court.
Doesn't appear to be, my lord, I will not join issue.
No,
My lord, your lordships were
Because
given
there was-
several statements
and
of
there was,
facts, my lord.
you don't know,
which are
and
not-
there was a complete ban imposed by the state of Maharashtra.
Lord, I do
And
not
that
know
was a
whether.
question raised before the court. Court upheld that ban, review was dismissed, and then the SLP was there. So the government was defending its action of putting a complete ban.
Correct, my
To
lord.
have bullock carts over there.
Correct, my lords, but thereafter, my lord, this new regime, my lord, ban is never perennial.
No, you are asking us
Tell me the
that
facts, how it came about.
25 must be a fact which the government of Maharashtra must have put in place before the court.
Yes.
Appears to be subject to what Mr. Mehta has to say.
So, where is your law? You want to put us in perspective, how it is done.
Yes, my lord. Yeah.
Where is the law at what page?
Find here. You have some.
Section 3. No, your lordships have not seen the act, my lord. I'm sorry. I went far beyond, my lord, a particular section, my lord. I was also racing with the act. Thinking, my lord, your lordships are with me.
Yes, we have got it. Yes, you can go ahead. You can go ahead.
Lord, kindly come to section 2.
Section 2.
Yes, this is the amended part. Bullock cart race, your lordship gets one.
Yeah.
Means, and my lord, now kindly forget, my lord, this replaces the ban. Correct, my lord, this replaces the ban. And after, my lord, expert committee going into it and recording a finding which are not understanding. Bullock cart race means an event involving bulls or bullocks to conduct a race, whether tied to cart with the help of wooden yoke or not, by whatever name called, with or without a cartman, with a view to, please mark, follow tradition and culture on such days and in any district where it is being traditionally held at such places as may be previously approved by the district collector. Well, checks and balances, the safety mechanism inbuilt and also known as Belgada Shariat, Chakdi and Shankarpat in the state of Maharashtra. Now, my lord, section 3. But please see insertion of subsection 2. Notwithstanding anything contained in subsection 1, the bullock cart race may be conducted with the prior permission of the collector, subject to the condition that no pain or suffering as envisaged by or under the act is caused to the animal by any person or persons in charge of the animal used to conduct bullock cart race, and subject to such other conditions as may be prescribed by rules under section 38B by the state government. This is what, my lord, section 11, subsection 3 requires. No pain or suffering, my lord, which is introduced. Now 3, if any person or person in charge of the animals conducts bullock cart race in contravention of the conditions laid down in subsection 2 or rules made thereunder relating to the bullock cart race or causes pain or suffering to the animal, he shall be punished with fine which may extend up to rupees 5 lakhs or imprisonment for a term which may extend up to 3 years. Strict punishment and exemplary fine, not just a token fine, to ensure compliance. Then 4, the conduct of bullock cart race in accordance with the provisions of subsection 2 of section 3 or participation therein with a view to follow and promote tradition and culture and ensure preservation of native breeds of bulls, as also their purity, safety, security, and well-being. My lord, there is a breeding, separate breeding takes place, and the breeding bull is also different. Your lordships are aware, my lord. Only pause here for a minute. My lord, the bulls, like horses, have pedigree. The horses, my lord, are also known by the pedigree, that he is son of so and so who won Derby, and daughter of son of so, mother is so and so who won so and so. Look, these are all those category of specialized breed bulls. Now 5, provided that nothing contained in this section shall apply to the conduct of bullock cart race in accordance with the provisions of subsection 2. Then 27 is amended. The conduct of bullock cart race in accordance with the provisions of subsection 2 of section 3 with a view to follow and promote tradition and culture and ensure survival and continuance of native breeds of bulls. Otherwise, my lord, as Mr. Dwivedi said, this breed will die if this is not to be employed in the racing purpose and not nurtured, taken care of, veterinary my lord, care is taken, then my lord, the only my lord, destination
Why
is,
you ban it if it is a part of your culture? There's a little contradiction there. If you are part of your culture, would you ban it?
because there was no provision, my lord, to ensure pain and suffering. Because of the incidental pain and suffering, now, my lord, that is removed. And my lord, kindly, my lord, at the cost of repetition, mere act of banning once, my lord, may perhaps not weigh with your lordships while deciding an act which takes away the basis of banning also.
Mr. Mehta, the argument was slightly different. The lawyer is not there now who appeared from Maharashtra. His argument was, if you see section 3 of the act, it's an unnecessary pain or suffering.
Correct, my lord.
And now you said with the notwithstanding clause of section 2 to section 3, and the term unnecessary is missing. You say no pain and suffering. The word unnecessary in subsection 2
Kindly, my lord.
or in the later part, the hammer in the substantive act is unnecessary, which the Tamil Nadu has taken a brief of the term unnecessary. But the term no,
No pain or suffering.
no,
As envisaged by or under the act. No, kindly see the subsequent,
Same as undue pain.
yes,
the lawyer's argument was
but it's qualified by the subsequent part.
Yeah.
But kindly for my satisfaction, read it again.
no, we are putting you the lawyer's submission which he made. The
I
legislature
understand,
in
my lord. We make
Maharashtra
submissions, my lord, but
deliberately deleted this word unnecessary, which is available under the Tamil Nadu.
But your lordships would, my lord, read and decide whether that submission is right. Please read, allow me to read it again, my lord, subsection 2. Notwithstanding anything, my lord, first see, my lord, subsection 3 of the principal act shall be renumbered as subsection 1 thereof and after. So, my lord, this is amendment of the main section. There is no dispute on that. Now, 2, notwithstanding anything contained in subsection 1, the bullock cart race may be conducted with the prior permission of the collector. Please mark, subject to the condition that no pain or suffering as envisaged by or under the act is caused.
What
It
do you
is
say
not
about
in-
11B? What do you say about 11B? How will you ensure that if the bull, if the bull does not want to run the race, it stands there at the start? How do you get it into action? Like,
No,
how do you
11
move it? How do you actually sort of activize it? So some-
11B
the section
of the main act.
11B of the main act.
You,
It says that if you cannot employ in any purpose, if it is unfit. Because in the case of bull in Tamil Nadu, it's slightly different. Here they are slim. They are actually, they are trimmed up.
that's a different breed.
Breed.
Would your lordships, my lord, I am posing a question to myself. Envisage a situation that a horse which is not fit is, my lord, sent for participating in the race.
The race.
Nobody can, look, that's exactly what this is. A
And
separate breed, separately trained, and people send it to win. We my lord, don't send it to, my lord, lose. So if it doesn't want to participate, it doesn't want to
The
participate.
rules provide for it specifically. Specifically provide.
So you will not hit it, kick it.
Could not be that prohibited under the rules, my lord.
No, but then does it really work on the ground?
My lord, it does.
Secondly, is it
No,
like-
only, allow me to answer this, my lord.
does it work on the
Lord,
ground? Have you,
Lord,
have you tried it? Have you videographed it? How the races are run?
yes, my lord, we have the videography.
Causing any kind of, pain.
We have the videography, my lord, but if your lordship would like to go through
Because
that
normally,
process.
even in the horse, my another brother was saying, I think you kick the horse. Some
No, my lord, kicking, my lord, every horse needs a little. My lord, therefore, my lord, it is unnecessary pain or something. My lord, when we, my lord, kill, we do, my lord, the people do kill with, my lord, full force. Kick, my lord, in horse racing, my lord, I don't think I need to argue on that.
That's
My lord, that's not, kick is not a cruel kick. It's an indication, a hint that now you have to start. It's like this. Not a punch, my lord. Not a punch. Punch, my lord, causes suffering.
Like our speaker earlier is.
My friend is talking about. You can
My lord, my learned friend may not do
Yes,
this.
this
My lord,
thing
we
is-
didn't do this. We didn't do this.
So I was just saying something in a lighter note when you, anyway, leave it. I thought you still detailed.
Yes. We just wanted to clear the.
You can say.
Oh, that's okay. I don't want to disturb you. I don't-
Yeah.
Lord, kindly see the rules. Rules provide for a pre-race checkup by the veterinary doctor. and the collector will give permission only if he is satisfied about full compliance of the rules.
Where do you get the rules?
Yes. Volume 1, my lord, page number 171.
Special interest also.
Lord, your lordships are aware, my lord, I need not elaborate on that. Possibility of a breach of law may not be a ground to declare the law to be bad. Then that particular instance needs to be punished. Therefore, the penal provisions that if you don't comply with, then you will be undergoing 3 years imprisonment and 5 lakhs, up to 5 lakhs of fine.
It's a counter affidavit filed by you in the Bombay High Court.
Yes,
Where it was challenged by somebody.
it's
The ban.
it's supporting the ban.
Supporting the ban.
Correct, my lord.
Exactly.
Now, Lord,
What you
these
say there, you might be curious to know what you said there, because sudden somersault.
Because-
That is evident in para 52.
we have not filed
Para
it.
52
Lord.
also.
You
this.
read para 52 of Nagaraj.
Only a minute, my lord. Lord, we thought, my lord, we would be defending the new regime. So that is not on the court. The old, my lord, affidavit which was filed defending the ban, etc., my lord.
My
Was-
grandmother wanted you to read para 52.
Para 52, my lord, I'll read them. I am obliged, my lord. Jallikattu, as well, your lordship, that para, my lord.
Yes.
Jallikattu as well as bullock cart races, etc., as an event, according to the board, violates section 3, 11(1)(a) and M of the PCA Act, read with Article 51(a)(g) of the Constitution of India. Ministry of Environment and Forest, in exercise of its powers conferred under section 22 of the PCA Act, as already stated, after noticing the stand of the board, issued a notification specifying that bulls shall not be exhibited or trained as performing animals. That position still stands. As on that day, there was a notification of the central government, which is now not withdrawn, long back. MOEF, it is seen, so far as the state of Maharashtra is concerned, is not recognizing that bullock cart race is a part and parcel of tradition of the people of Maharashtra, and that it has cultural, historical, or religious significance. The state of Maharashtra, in its order dated so-and-so, has clearly acknowledged that organization of animal sports in the state, mainly in its rural hinterland like bull, ox, bullock cart race, etc., is nothing but violence to the dumb animals and has to be prohibited. The state government evidently did not give its stamp of approval to the so-called cultural historical importance to the bullock cart race, and that order has not been challenged. But so far as the state of Tamil Nadu is concerned, now a proposal has been made to exempt bulls participating in Jallikattu, which Maharashtra did, my lord, which is before your lordships.
So you are not anchoring it to cultural thing, but it's on a clean slate, you are introducing a.
No, my lord. No, my lord. The report. Kindly, my lord, now come to the report again, my lord, that it is a part of the culture. The view of the state government earlier. Anand? No other matter. Kindly come to, my lord, page 31, the report, my lord. My lord, the government of the day, my lord, whenever they thought, my lord, that this may not be a part of the culture. But ultimately, my lord, how we establish, your lordship's question to Mr. Dwivedi was right, that on what basis you establish that it is a part of the culture and tradition. Some expert committee will have to go into it. The expert committee went into it. And this finding of this expert committee is not a subject matter of challenge. No, before your lordships, it is nobody's case that this is not a part of culture, except, my lord, some old statement made by the state government at the relevant point of time. Please say, my lord, page 31 of the report. Your Lordship's, to our advantage, but your Lordship's mic is on.
I don't know about you would have heard what.
No, my lord, not fully. My lord.
Why this matter has come here? It should have been dealt with by the Bombay High Court.
I know.
That is what my.
That's what my lord, your Lordship was saying, but when I realized that your Lordships are audible, I thought it to be my
That's
duty, my
right,
lord,
that's
to point out, my lord, that some privileged communication may not be heard, my lord. My lord, there are books, my lord, and I'll place it. I'm not going to read it. In Tamil Nadu, my lord, this tradition is, my lord, thousands of years back. And one of the author of the book is one of the petitioners, I'm told. Lord, it's my lord, nobody's case that it's not a part of culture. It's not a part of, my lord, custom. The only argument, my lord, essentially is that there is some pain, whether you have taken care of it by way of statutory mechanism, and if that is repugnant, whether there is any assent. Assent is also not under challenge. Arguments are essentially based more on compassion than on law. Your Lordships are on page 31, just overleafing, my lord, the findings given that this is a part of the custom and tradition in Maharashtra. And this is, my lord, post Nagaraja judgment and post ban and post, my lord, affidavit filed by one officer that this is not a part of the culture. Look, this dates back to Harappa civilization. My lord, as a matter of fact, my lord, forget the race. The relationship between human and bulls dates back to Harappa civilization.
Then
Yes, my lord, there is a change of decision, my lord, but in accordance with law.
What we feel is that whatever the amendments are made in the state of Maharashtra, we don't find they were required at all. Because no substantive changes are made except you put the bullock cart as one of the prominents to show that what is the role of why we want bullock cart to be introduced in the state of Maharashtra. What we feel is that in like of Tamil Nadu, whatever the amendments were made, followed with the relevant rules, the same practice was followed in the manner of putting bullock cart in place of Jallikattu, whatever the thing is, in state of Maharashtra, and the corresponding rules were made. Otherwise, you will see back to the amendments in the Maharashtra here, except you put bullock cart as such. What additional you have said? Nothing. The substantive act of 60 remains the same.
No, the distinction is, I can't, my lord.
This is only because what happened earlier when the matter came to this court, there was a ban first imposed by the central government under 2011 notification, followed by the state government in sequel there to put the ban. That ban was under challenge. So state and the central government were defending their ban under the Act of 60 itself. Now this matter traveled to this court, your affidavits were because of these good reasons we have put a ban. And that was upheld. Para 3025 which you read is in reference to the stand of the state government before this court.
Correct, but
now you made an amendment of 2017 and then you say new regime.
No.
Also, they said that it was not part of the culture. There your stand was.
Lord, I can't reflect. No, I can't. I'm sorry.
There in para 15.
Lord, if your lordship thinks, Lord considers that once a ban, even expert committee cannot be relied upon, my lord, matter ends. There was a ban, some officer did say it's not a part of the culture. Thereafter, a committee is appointed. I'm trying to show to your lordships the committee report on my lord, how it is part of tradition and culture.
Give us the rules. Give us the rules.
My lord, kindly allow me, my lord, to show, my lord, how it is a bald assertion vis-a-vis, my lord, subsequent going into the facts.
Where are the rules?
Yes.
Page 150.
Page 170.
151 it is there.
170, my lord, of
Volume 1.
Compilation document, convenience compilation.
170.
170,
7.
170.
Take 157. Yes,
One
take the
seven.
same page 157.
सवाल है सारे.
This, this photograph showing.
Oh, your lordships are on the report. I'm sorry. I
No,
thought
yeah,
I was on rules.
We'll go through the rules, but he just wanted an essay.
Yes.
This is a photograph at page 32,
Yes.
where it is now pictured, picturized as part of bull racing.
Yes.
Isn't it not really an act of a farmer carrying out plowing?
Can be.
Huh?
This is to justify, my lord, the car.
That's right. But what the report says, it is a bull racing.
My lord, let me read the report, my lord, and if your lordship would like to, my lord, declare that this report is possibly
This report,
inadequate.
we are only asking you
Yes, my lord.
that we thought that, you would have seen how the farmers, they plow. They will also have a stick or whatever they have.
They should stop now.
Just stop. So this particular photograph, you're just saying, it has been associated with bull racing. What you're saying is it looks more like plowing.
Lord, if my lord, we have to take a second look and second view, Lord, possibly that can be taken, my lord.
That's right. No, the point is what we are concerned is how does the state at one point of time assiduously ban and vigorously defend the ban, saying it is not part of the culture. Then suddenly one side body is not with
Lord,
too
that-
remote. Suddenly say, no, it's part of the culture. We can't take
I'm
that.
sorry, my lord. I'm sorry, my
Tamil
lord.
Nadu is very consistent. Tamil Nadu is throughout held it is part of the culture.
Lord, only thing,
In the review petition, they argued it is part of religion. Please appreciate.
Culture, it
No, written at 25 and 29. There's a difference.
we can't draw lines in that.
my lord, the only distinction between the earlier stand and the present stand is the committee report, reconsideration by the government, and my lord, it is the entitlement, my lord, of the government to reconsider its decision based upon, my lord, the report of the expert committee.
Yeah.
But that's, my lord, I don't think, my lord, would be a disputed proposition as a law. Now, my lord, I am coming to the question of assent.
Yes.
Lord, please note, there is no challenge to the assent. After, my lord, your lordship's query on the last occasion, they have suddenly, my lord, given some draft amendments, and I would request your lordships not to entertain a challenge to the assent, because there was none, and it cannot be made at the last minute without my pleadings being on record.
Yes.
So far as the files are concerned,
Yes, please go ahead. Now, what is the assent part?
yes, Lord, at the outset, straight, my files are here and I'll give it to your lordships. There is no difficulty at all. Now, Lord, allow me to say something as a proposition of law. Lord, the files may be given first.
And just give it so that, in the meantime, we'll see it and then.
No, Lord, that's the problem, Lord. I would wish your lordships to hear me also.
That's right, we
Yes.
hear you.
Not in the meanwhile, your lordship may do it after.
Once you go away, we can't ask you anything.
No, Lord,
We need to get you here.
on the lighter side,
In
Lord.
life and blood.
Please don't go through it while I'm arguing. That's all I say, Lord, on the lighter side.
Otherwise, we'll not be in a position
But-
to ask you.
Yes, my lord, now I'm, my lord, submitting the written.
There's nothing, it'll be there, the assent, everything will be there. I think.
It is there, my lord. But, my lord, it is only, my lord, for your lordship's perusal.
Correct.
Any documents, my lord, these are all constitutional decisions signed by the President of India. My lord, I would not wish anybody else to see it. There is nothing confidential about it, but there is a sanctity about it. That's all. Now, my lord, kindly, my lord, see, my lord, this is my written submissions. I want to read one judgment. And your lordships may, my lord, kindly thereafter. And this law, my lord, stands today. It has held the field, my lord, and is a good law. Well, just to assist your lordships, my lord, what would be the parameters within which your lordships would also be looking at the file? My lord, ultimately, your lordship knows, my lord, the presidential assent has its own constitutional sanctity, not that it's not subject matter of a review, etc. I'm not pitching that high, but the parameters would be, my lord, the threshold would be very, very, my lord, high. Kindly come to page 21, right side bottom is the pagination.
Yes, we got it.
Yes, my lord. This is, my lord, Cassere Hind, Lord, the landmark judgment, my lord, which deals with this.
That's right, that's right.
In the efforts.
Morning we were taken through para 20, 25. So
Yes.
we can avoid reading it because we have read that.
Yeah, yes, my lord. Kindly, my lord, come to 25, my lord, once again, my lord, for this purpose, assent, for the purpose of assent, my lord. In our view, for finding out whether the assent was given qua the repugnancy between the state legislation and earlier law made by the parliament, there is no question of deciding validity of such assent, nor the assent is subjected to any judicial review. Here also, there is no challenge to that. That is to say, merely looking at the record for which the assent was sought would not mean that the court is deciding whether the assent is rightly, wrongly, or erroneously granted. The consideration by the court is limited to the extent that whether the state has sought assent qua particular earlier law or laws made by parliament prevailing in the state, or it has sought general assent. In such a case, the court is not required to decide the validity of the assent granted by the president.
That's right.
In the present case, the assent was given, etc. Then 65.2. Article 254.2 contemplates. Lord, kindly, my lord, see para 27 of, my lord, it's not quoted here, my lord, but it's, my lord, I have given, my lord, that's, my lord, something relevant, my lord. My lord, it's crystallized for your lordship's assistance in the judgment.
So we are listening. 2002. We have noted it.
Would your lordships like to, my lord, listen to it? My lord, I'll just read. Para 27. In this case, we have made it clear that we are not considering the question that the assent of the president was rightly or wrongly given. We are also not considering the question that whether assent given without considering the extent and nature of repugnancy should be taken as no assent at all. Further, in the aforesaid case, before Madras High Court, also the relevant proposal made by the state was produced. The court had specifically arrived at a conclusion that Exhibit P12 shows that Section 10 of the Act has been referred to as the provision which can be said to be repugnant to the provisions of the code and the Transfer of Property Act, which are so and so. Now, last paragraph, Lord, unnumbered para. In any case, does my lord say, Lord? In any case,
Which paragraph?
as the same paragraph, last 4 or 5 lines, my lord, after before one, my lord, before bracket 1. In any case, my lord, classitum D. In any case, as discussed above, the essential ingredients of Article 254.2 are 1. Mentioning of the entry or entries with respect to one of the matters enumerated in the concurrent list. 2. Stating repugnancy to the provision of an earlier law made by Parliament and the state law and reasons having such law. 3. Thereafter, it is required to be reserved for consideration of the President. And 4. Receipt of assent of the President. Now, para 30, next page. Finally, we would observe that challenge of this nature could be avoided if at the commencement of the Act it is stated that Act has received the assent with regard to the repugnancy between the state law and specified central law or laws, because the legislature, whenever mentions something, it is treated to be sacrosanct unless established to be factually incorrect. Here, my lord, all the three legislations mentioned, all the three, my lord, acts mentioned in their statement of objects and reasons that it was reserved for the Honorable President and referred for the presidential assent, and the President has granted the assent. And in any case, my lord, grant of assent is not in question. This is only, my lord, respecting, my lord, your lordship's word that my files are here, and my lord, I will submit it for your lordship's perusal. There is nothing to hide from the court. But my only worry is, my lord, that this may not become a precedent, that in every case the files which are ultimately signed by the President, my lord, are called for and, my lord, are subjected to scrutiny. But your lordships can definitely look into it. But all the three acts, my lord, all the three files are here. They are original, my lords. My lords,
Karnataka,
Tamil Nadu and Maharashtra.
That's right. We'll just go through.
My lord, your lordships can, my lord, retain it and can return it subsequently also, but there is no difficulty.
Yeah.
Because multiple ministries are involved, their opinions are taken. Once in one of the matters, the opinion of the then Lord Law Officer, the learned attorney is taken. And my lord, it's thereafter, my lord, the Honorable President, my lord, one there are two presidents, my lord, because of the time gap, and all the three are signed by the Honorable President. Lord, I would only make one request. Lord, because of Lord respecting the lordships, Lord, desire, Lord, to peruse the file, Lord, we have given this. Kindly don't record this in the order so that it doesn't become a precedent. Your lordships are in a file judge. I'm sorry, my lord. Lord, my respectful request is this. Lord, Lord, there is an earnest request. Can consider
Attention. Otherwise, we would not. Para 20. You drew our attention, para 27.
correct.
And towards the end of that para, it is said, we do not think that in any case as discussed above, the essential ingredients are mentioning of the entries with respect to any of the
Yes,
matters.
I've read that. I've read.
Then you said, stating the repugnancy to the provisions of an earlier law made by Parliament and the state law and the reasons for having made the law, thereafter it is reserved for the President and then. So we are only taken up with the first two.
Lord, I know, my lord, I am before
Stating the repugnancy.
I am before the Constitution bench, and your lordship knows, my lord, this is not the statute we are reading. We are reading the judgment, and your lordship knows the ratio, my lord.
So the ratio is in this manner.
Lord, your lordships can, my lord, have the files, but allow me, my lord, to make my request, my lord. I am trying this, my lord.
Yeah.
Yes, my lord.
Your request
Lord,
is.
please do not record that the files were perused. Your lordships are in a Constitution bench combination. Lord, this becomes a precedent, and that worries all of us, my lord, as officers of the court. That the decision taken by the president was looked at and was reviewed judicially in absence of the challenge also. That's my worry, and therefore, my lord, please do not undertake, my lord, that course of action.
The president's assent is being called, we wanted your enlightenment so that you can tell us. That the president's assent is called in question. It's really not an assault on the kind of dignity of the high office of the presidency at all involved. In a country which is governed by the rule of law and by a written constitution, we are just wondering what response you will have. You will certainly have a
I
response.
would not rather give the response. Your lordship knows the law on the point.
No, the point is only this.
There is no question of lowering the dignity. There is a question of constitutional sacrosanct,
So it is
constitutional.
never meant as an assault against presidency or against.
Lord, it is considered if it goes, my lord. Anyway, my lord, I will not.
There's no challenge. There's no.
My lord, it would. I'm my lord. I'm my lord.
77 is quoted in Kendra in submission very clearly.
My lord, only one thing, my lord. My learned senior is right. Even if there is a challenge, your lordships will have to prima facie be satisfied that the assent is bad, and then only the files are called. My lord, not, my lord, I'm sorry for using this, my lord, but not to satisfy intellectual curiosity. My lord, these are all constitutional sacred things, my lord.
Foundation should be there.
Yes, factual foundation, challenge, and the prima facie case, so that your lordships can examine.
I wonder which.
I'm not taking this, my lord, as an ego matter.
We only want one thing to know. Under which ministry does prevention of cruelty to animals fall actually? Just we want to get you tell us.
At that time, there was Ministry of Environment and Forest. Now there is a separate ministry.
At that time, it was dealt with by the Ministry of Environment.
Environment.
We just wanted to know that.
Yes. It's there in the file, my lord. At the relevant point of time, it was MOEF whose opinion was taken. And my lord, this ministry which deals with the Honorable President is the Ministry of Home Affairs. The my lord, aid and advice of the Honorable Home Minister is also there. My lord, there is a.
No, we want to know. Mark it off.
The law.
We are
Just factual thing. One factual thing.
Only a minute. We are
No,
not
one
on.
minute.
We are not on factual. We are on constitutional.
Please.
Lord, we are traveling, my lord, an area which the lordships may avoid.
Lord,
Lord, please do not do this.
Lord, just one. Lord, I just want to clarify one thing.
Just a moment.
That where is the challenge?
Yes, I am showing that because I only added.
And the foundation.
There is a foundation. I want to show that because your lordship didn't take the amendment. The amendment only adds one particular thing, but the foundation is there. Somebody should read it. But the point.
Lord, unless the prima facie case
Yeah, I'm
of.
saying that there is a foundation in ground. You may just read that because your lordships are told repeatedly there is no foundation. Let me just read that.
Look, can I?
Yes, please, Mr. Then you can answer your point. In Kesara Hind versus so and so, this honorable court held that there can be no concept of general presidential assent, that the president ought to be properly informed of the possibility of repugnancy and the extent of the same.
Lord, say something, my lord, I can say
I'm
something.
just actually correcting you that there is.
Lordships are sitting in appeal over the. My lord,
I think, we are not sitting in appeal.
Lord, I want
Can your lordships allow me, my lord, 2 minutes?
Yeah.
The page from which he is reading is given on 28th November during the midst of the hearing.
No, I am on a different point. Ground.
He is reading this ground, my lord, which is
Just
kindly.
allow me because I don't want to be told again, don't argue. ground Q makes out the factual foundation.
In the midst of the argument,
No,
only
please,
because my
you
lord
are not
Justice
given
Joseph,
enough
my lord,
time to-
inquired from me, my lord, they
You're
are now
just
coming out with the ground.
Unfortunately, my lord, lordship that day said, please stop. I stopped.
Lord, it would not be fair to me, my lord. That's all I have to say.
I only want to read ground Q, which is the factual foundation.
Just tell us the ground, that's all.
Ground Q.
And
All
the
the
date on which it is raised.
All
And the date on which it is
all
raised.
the three writ petitions by Fiappo, ground Q.
Okay.
This is 28th of November 20. Advice given by the Council of Ministers, which is constitutionally prohibited from court's examination. Lord, I am avoiding going into, my lord, an area, my lord. I merely respected your lordship's word and place it for your lordship's
You
consideration.
see, when the files are there, you are well aware of the law. It is only the advice per se. Advice per se.
But your lordship's mic is not on.
It is the advice per se. It is not the entire cabinet papers, which, as you know the law, I think we don't have to tell you what the law
Lord, your lordship also knows the law, my lord, on this subject, my lord. I am saying something else. Lord, Lord, if your lordship would like to, my lord, consider.
I am only on that. My worry is only that. what is troubling us is only one aspect, and our problem is whether putting that question to you will sort of be a constitutional sort of heresy. To sort of ask you that question and elicit an answer will involve disclosure of things, which
It would, my lord, and it should be avoided. And one more thing, my lord, with profound respect, Lord, whenever a constitutional decision is not even in question, I hypothetically assume it is in question, what will be the procedure, the rule of law which your lordship said would follow? A factual foundation that this is bad for ABCD reasons. Your lordship's prima facie satisfaction that yes, it appears to be bad for ABCD reasons. It is only thereafter that the court would call for the files. I suggest, Lord, Lord, I would wish to, my lord, address your lordships on this question, my lord, in absence of any challenge, suo moto, whether your lordships, my lord, would be.
Sumoto will not do it, but there is a challenge. There is a challenge.
Lord, I have repeatedly said, possibly I missed your lordship's attention, that challenge was after your lordships indicated on 28th of November. I would like to file my reply, my lord, and address your lordships on the contours of the jurisdiction.
It was not there earlier, prior to that.
Not the original petition filed 5 years ago has that pleading. In the amendment, I only added one sentence. If your lordship doesn't want to allow the amendment, it's okay. But ground Q makes it very clear, my lord. I'll read it out because my learned friend possibly may not have read it. It says in Kesar Hind, etc., this honorable court held that there cannot be no concept of general presidential assent that the president ought to be properly informed of the possibility of repugnancy and the extent of the same when seeking his assent in the passing of the ordinance. Therefore, it is clear that if the repugnancy contained in the act was not communicated clearly to the honorable president, it is open to the courts to interpret whether the due process has been followed. So the factual foundation is there. No, but somebody has to.
There-
No, there is not a factual.
There is no
foundation.
factual, this is just
I'm
a
saying-
bald assertion, my lord.
This is the statement
Make
of
it
the
un-
law. It's a
No,
statement
please,
of
let me
the factual
finish.
foundation.
But this is not fair. Right through, it's always
No, that
interruptions.
is not,
I have not interrupted anybody. Not,
You are
even when, no, I'm sorry, Mr. Sibal, don't say that.
Yeah.
We don't have the information about the president's assent. How can
Lord,
we
your
say
lordship,
it was
would your
not there?
lordships, my
We
lord,
can only
hear us, my lord.
speculate. We can only speculate.
Would your
We have
lordship,
speculated and we say it's open to your lordship to interpret it. I'm not even asking, my lord.
speculation is not a ground, my lord, to make out a challenge. There is no challenge. They have made a statement of law in ground Q. That this should be, in absence of this, it cannot be, that's all. If your lordship,
Yes.
Lord, then, my lord, your lordships, may, my lord, we would address your lordships on this. Your lordships may, my lord, allow us to have, my lord, the arguments on, sorry.
Do you want us to speak our mind? Do you want us to ask questions? Or do we, do you think that
Your lordship's mic
we
is
should
not
not
on.
go into? The mic. Sorry, the mic. Do you want us to ask you what is troubling us? Or will you, sort of shelter under the advice theory that you can't go behind it? In which case we will say no.
Your lordship will say anything.
What you're saying is there is something which we found there, which troubles us. In keeping with the law which you laid down, I mean, which you drew our attention. We are grateful to you because nobody read that portion.
I'm grateful, my lord.
We are really grateful because none of them actually brought that to our notice. That last part of para 27. The ones that is brought to our notice, what we saw is what troubles us, so that we will keep.
But I would like to address your lordships whether the file can be gone into in absence of, Lord, any factual foundation being laid. I'm not concerned with this case. I'm concerned with, my lord, the rule of law being prevailed, my lord, on both sides.
Yeah.
And, my lord, then kindly, my lord, have it, my lord, we'll address your lordships on the question of contours of this jurisdiction. I thought your lordship would like to just peruse, my lord, and I have, in good faith, my lord, given that there is nothing to hide. Henceforth, we'll be careful.
Argument. If you have concluded, we'll postpone.
These are my submissions.
These are your submissions.
And if your lordships are going to, my lord, examine this, I would earnestly request, my lord, to allow all of us, my lord, to address on the question of contours of court's jurisdiction.
All right.
It was, Lord, by way of, my lord, profound respect that your lordship's wish was, my lord, fulfilled, without, my lord, going into that question. But,
Mr. Mehta, do one thing, give it a short brief in writing also.
no, my lord, on that, my lord, we would all like to address your lordship. My lord, if it is,
Give it in writing to us.
no, my lord.
Whatever judgments you want to rely
No,
on.
no, my lord. In absence of a challenge, my lord, in absence of a challenge, we would like to address your lordship on this question.
But I'm sorry to say, but there is a challenge. I
There is
cannot
no, we
understand.
see the,
Maybe
show the
my
player.
understanding of English is all wrong, but in my respectful submission, there's sufficient ground of a challenge. Please
No.
read ground Q in all the petitions.
We also have a different understanding.
Yes,
As we have learned,
my lords.
grounds, if you see the affidavit, grounds are advised by the lawyers.
Yes, but how do we,
But the factual foundation is by the person who plead.
correct, now
And
let's,
the person who plead is the petitioner.
yes,
So it is his pleading which is supported by the assistance of the lawyer in framing the grounds. That's what we have learned about it.
no,
That
fair-
according to us is
fair
the pleading.
enough, fair enough.
God knows what kind of
No,
pleadings are.
maybe, my lord,
As we have learned, this is the pleading system.
Lord, please,
Yeah,
Lord,
obviously.
I assume, Lord, your lordship.
And no
will
prayer,
absolutely
no
right.
prayer.
Facts are pleaded before the grounds. Grounds are just relating to the, now, Lord, in this case, when the assent and the papers are not even available in court, how do I make a factual foundation
Well,
except
this is not-
speculate? How can I say, no, it's not there? I have to speculate.
So that, you mean to say that in all cases where assent is there,
Who is arguing?
you need only to make a general
No, I will
statement
say,
and then
no,
ask
I
production of
say, this is the law, in this case it's not followed, that's all I'm saying.
Leave it to us. We will-
Very well, no, because my learned friend is saying, that's all.
Whatever
We have
you
actually asked for the documents, they have not given them.
But you did not challenge it.
Lord, please see ground Q, my lord, please see ground Q.
Have you amended the prayer?
No, I have actually taken a ground Q to challenge the act. I don't have to
Your
make a,
ground has no.
why should I
factual
make a
foundation.
prayer?
It's a legal submission.
Yeah.
based
Yes,
on
I
lawyer's
can. Why
advice,
can't I?
that's all.
Prayer is to strike down the law. I can't say no, prayer, give me this. Grounds are necessarily the basis for a challenge to the act.
Assent is based on a constitutional procedure. The challenge.
I have
has
also
to
asked
be
them to
that
produce the
a
document.
particular procedure has not been followed, therefore the assent of the
That's what it
president
is,
bad.
ground Q.
You said, I do not know, it's speculative, I want to find out whether it's bad or not. You can't do that.
Why not?
For distinguish, because you do not know what the procedure is and you are challenging it, and challenge is speculative.
Not
There is
speculative.
no factual foundation for your challenge.
You know you haven't followed.
This is a
You don't
serious
disclose it.
Challenge.
There is
You
no
know you're
challenge
not
at all.
following, you don't disclose it.
You know,
It's clear in ground Q.
every presidential consent will be challenged that this is bad and therefore the file should be shown.
It says that they have.
What kind of legal argument is that?
Let us go through the file, we'll make up our way, capable of taking.
So just see para 77 of case again also.
No, we want, who's arguing next?
What, Mr.
I just want to
Unlike-
complete one thing on Maharashtra, my lord. On the change of the stand of the state, because it was said that earlier in 2011 we had a particular stand. Can I just complete the factual narration there, because I have something to show there.
What more, it's already 3:30.
It'll-
We can't go on like.
It'll only take me 5 minutes to place it that we've not changed our stand.
Give it a written note.
My lord, can I-
Written note.
Written note, there's no need to.
No,
ask
I
it
just,
again.
no, I'm giving my written note right away.
That's the way, that's.
I won't even read it. Let me just point out what it was.
not this.
Can I just tell your lordship what it was? It'll just take me a minute. In 2011,
Yes.
well, I'm just telling your lordships, I'll put it in a drop. Now, my lord, your lordships in Nagaraj showed para 25, rather saw para 25 to 29.
Hold on.
We'll go through the file. I don't think the problem, when we see the file in greater detail, the probably the issue which we raised may not be there.
That's right. That's what I thought, Mother.
We will let us go through it.
Yes.
Please.
My lord, this is what I was saying. Sorry, your lordship.
Doesn't have this.
No, no.
Complete whatever.
All I was saying was, my lord, your lordship saw in Nagaraj, there was a 11/7/2011 notification followed by a 1/8/2011 notification of the state of Maharashtra. Just hand over my submission. I'm not placing those submissions. Now, thereafter, what happened was, my lord, the state of Maharashtra, at para 29, it is mentioned, of Nagaraj, issued a corrigendum dated 12/9/11, clarifying the difference between a castrated and a non-castrated bull and permitting castrated bulls to race. Now that was challenged before the Bombay High Court, and the Bombay High Court passed a judgment saying all bulls should be treated equally and they should be banned totally, and that the state was directed to notify. Therefore, my lords, this 20th/4/2012 notification came. Now the matter travelled to your lordships court, Supreme Court, and on 15 February 13, the state said, no, we don't want the ban. Therefore, with conditions in the order, the ban was overturned and racing was allowed to go on.
Yes.
That is what I wanted to tell your lordship, that therefore the state of Maharashtra has never changed its statute. Those orders, my lord, your lordships will find in Maharashtra's volume 6 compilation at page 4 to 7 and 12, to say that Maharashtra had always taken a consistent stand. It's not that we said at one point there should be no racing and later that there should be racing. I've also given a more comprehensive note, but on this, please permit me to give 2 pages.
Yes.
All right, oblige.
Yes.
Lord, I have 2 submissions to make. One is, my lord, in
Yes, Lothar. Please go ahead, please go ahead.
Lord, I have 2 submissions to make
You are appearing for?
for my lord Tamil Nadu. But Lord, I will not talk about what has been argued. I have 2 submissions to make. One is in respect of Nagaraj, and one is in respect of the current scenario.
That's
In regard to Nagaraj, is my submission that Nagaraj, my lord, does not lay down correct law. There are several petitions, my lord. So I want to make a completely different line. Lord, I am making a completely different argument. And Lord, I will make it very briefly, Lord, as
Yes.
short as possible. My submission is that Nagaraj is incorrectly decided.
Oh.
And Nagaraj, my lord, is the basis for this petition before your lordship, primarily. Now, Nagaraj, my lord, has 3 pillars. 1, repugnancy. 1, the 3 reports of the board showing the prevailing position then. And the 3rd, that animals have statutory rights, which have been raised virtually, my lord, to constitutional rights. So these 3 pillars, my lord, of Nagaraj, in regard to 2, my lord, namely repugnancy and the scenario. Repugnancy, my lord, is met by virtue of assent, and the scenario then prevailing is taken over by the scenario now prevailing, which is based, my lord, on the rules which your lordship saw, and the stand of the board now in writing that for the years 18, 19, 20, 21, they have used this plot. The board now says for the years 18, 19, 20, 21 and 22, there is a sea change in the scenario, and by virtue of the rules which are being strictly implemented by the state of Tamil Nadu, the position then obtaining does not obtain today. That's what they say. So we are left, in my respectful submission, with the issue of rights of animals. And I respectfully submit, and I'll show you some passages, that the judgment proceeds on the premise that they have rights, animals have rights, because humans have duties. If humans have duties, animals have rights. I'm only paraphrasing it for shortage of time. This is what the judgment says. Because humans have duties, including the phrase humanism. In 50,
Speciesism.
and humanism, both belong. In 51A, G and that provision belong of duties. So if humans belong have duties, animals have rights. And those rights are under 3 and 11. And they have to be protected, which means, Lord, that they could be statutorily enforced. If you have a right, you have a right to enforce it. Otherwise, what's the right? This is the basic law of their judgment. I respectfully submit, Lord, there is no warrant either in our constitution or, Lord, in this act to say that, Lord, the duties on humans leads to a corresponding rights of animals. And those rights, Lord, if I may say so, the rights, Lord, under this act have been intermingled by the judgment to rights, Lord, flowing from 51A and, Lord, the 5 freedoms of an international obligation, 5 freedoms, 51A and 3 and 11 have been, Lord, mixed up to say that this is the compendium of rights in the judgment. I respectfully submit, Lord, there is no warrant in our constitution. And if I may say so, Lord, the judgment at one point pitches it at Article 21. But when it comes to directions, Lord, it recognizes that it is not 21, but it should be elevated to 21 by Parliament. That's what, Lord, the compendium is. I submit, Lord, there is no warrant. Kindly, Lord, have a look at the act for a second and then, Lord, the judgment. Lord, your Lordship will find, Lord, your Lordship has read 3 many times. I don't want to read it again. It talks about, Lord, unnecessary pain, etc.
Yeah.
Now, Lord, the judgment starts by saying that if you have a duty, a human has a duty. Otherwise, what I'm trying to drive at is, Lord, the duties and rights are between humans. That is morals, ethics of a society. 11 is nothing but morals and ethics of a society. You will not behave in this fashion. You will not do like this. Lord, even in humans, there has to be orderly conduct in a community. You will not kill somebody, you will not rob somebody. Those are our morals. Law is nothing but, Lord, a compendium of this.
They may not be ethics, but they actually constitute the ingredients of an offense.
Correct. I'm very grateful. So, Lord, these are morals which, Lord, people must adhere to on the.
Not morals. It is a legal duty, as you correctly
Or a legal duty on the pain of sanction. My Lord is right, on the pain of sanction. If you don't do this, you will be disorderly.
That's what we pointed out, salmon.
Correct. Lord, the salmon is referred to, Lord, in the judgment. If your Lordship will have a look, Lord. The judgment starts by saying, and if I may say so, Lord, without any precedent. There is no precedent. That 3 provides for rights of animals, and therefore there's a duty on humans. You are, Lord, putting the so-called rights of animals with a corresponding, Lord, or a duty on humans with a corresponding right of animals. There is no warrant. It is not prescribed anywhere, not in our constitution.
Can an animal
Yes.
possess rights, legal rights?
Correct. Very. My submission is, Lord, no.
No circumstances.
No. In our constitution. In some constitutions in the world, or some, Lord, agreements in the world, people have recognized it.
Does entry 97 of list 1, which is a residuary list for parliament,
Yes.
clothe the parliament with regard to legislative power to make laws in
Yes.
respect of matters which are not found
Of
specific?
course it can. Of course.
So can animals, we are again asking you, be the subject matter of...
It can if Parliament so decides. No doubt. But Parliament has not decided. Parliament has not decided either by this law, Lord, or by the Constitution. And importing.
Parliament can create legal...
Of course, Parliament can, no doubt about it. And, Lord, your Lordship, remember, there is a word of advice in the last portion of Nagaraja that we expect Parliament to do this anyway. No problem. Like the Lordships have said, Parliament may not. There can't be a mandamus to Parliament to do this, that, and the other, but that, we were not on that field. I am only saying, at the start of this judgment is that 3, which is an injunct, really speaking, on a human being. It's an injunct by society which is represented by Parliament. That look, when you exist in nature in this world, this is how you will behave. And if you don't, as my Lord rightly said, it will be on pain of sanction. But that does not mean that a human being, by virtue of this injunct or duty or morals or duty, whatever you call it, will give a corresponding spring, a corresponding right in an animal. Otherwise, the law would have indicated so. Contrast it now. Fundamental duties and directive principles are not enforceable in the court. They exist for humans. They exist for citizens. So even citizens in this country cannot enforce fundamental duties or directive principles against the state. Because Lordship knows, I don't need to read them, from 39 downwards, adequate livelihood, adequate health, adequate this, that, you can't have. You strive for an ideal world, but it cannot be enforced. If a fundamental duty or a directive principle cannot be enforced, and it is elementary, settled law, you can give lots of judgments, but Lord knows it better than I do. If fundamental duties, and directive principles cannot be enforced by humans against humans or a state, which is state is also a body of humans. If that cannot be enforced, how is it that the rights are contemplated of animals which are intermingled and interspersed with fundamental duties under 51A? That's what has happened here. If I may say so, the judgment is overbroad. It's overbroad. It forgets the distinction between rights and duties. There is no such thing as between men or humans and animals. And it just proceeds on that. There is no precedent in Indian law or the Constitution. That's how it is proceeded. No, have a look at 11 for a second. See 11, See, beloved. So this is an injunct on the human. Don't do this, don't do this, don't do this, don't do this. If you do this, sanction of law in 11. Have a look. If any person beats, kicks, overdrives, employs, etc., or causes unnecessary pain, etc. But keep going further. Keep going further. See, C. Willfully and unreasonably administers. See, F. Keeps for an unreasonable time an animal chained. How are we going to be enforced?
They are ingredients of offences.
No,
They are really ingredients of offences because shall be punishable.
I'm going to read that. I'm only trying to say, an animal can't come forward and say that I'm being unreasonably chained. But Lordship is perfectly right that it is, an injunct on you. If you do this, you will be punished. No problem.
Somebody on behalf of the animal can come.
With great respect. That presupposes the point that the animal can go to court.
No.
It's like an attorney or somebody else.
We are putting it in a different way.
Yes.
That just because the animal cannot go to court itself for himself or herself.
I appreciate. I am only saying, there must be a foundation in the law or the Constitution to say.
On that we have.
Yes.
Are you saying that the animals are they are not having any enforceable right, and therefore somebody cannot come forward to enforce it?
Right.
When they are not having any.
No, I'm saying they don't have any right.
That is what I.
Enforceability is a second. They have no right.
Because you said that the fundamental duties and directive principle, even the human beings cannot enforce.
My Lord, I'm grateful. That's why I'm
Therefore,
drawing.
that is
I drew that. Yes, you're right. I drew that example because this judgment has intermingled fundamental duties into this 3 and 11. There is no basis.
give you two further examples,
Right.
which perhaps take your argument forward a little.
I'm grateful.
There are laws which prevent, cutting of trees.
Correct.
Trees have life.
Yes.
They also have life.
Correct.
Can it be said that trees have rights?
This, Lord, I was going to say that.
Take, for example,
You had the Chipko movement
take water.
4 years ago, Lord.
You take
Yes, your Lordship is right. No?
supposing the effluents can't be, put into, ocean or whatever it is. Will the ocean, will nature have rights?
Correct.
Is it or is it an ingredient of an offense?
It's ingredient of an offense. You spoil environment, sanction of law. Spoil an ocean, sanction of law. Otherwise, Lord, it'll be an anathema to our the way we think. It's all humans. This is how it is. Humans have to live in an orderly form, which is the society. These are rules. As my Lord rightly said, you spoil this, you'll face sanction. You do this, you'll face sanction. There is no right in that tree or grass or a vegetable that you are cutting it, Lord, at a particular time. You can't do that. The judgment will not be great respect. Call it per incurium, call it sub silentio. I don't want to get involved in that debate. There's not much time. But when you start on first principle and say that 3 and 11 is a statutory right and therefore a duty on Milord an individual, that Milord, the respect Milord is not palatable. I want to show you one more thing. Milord, my Lord recalls in the earlier part of this discussion, there was a lot of discussion in the judgment about amusement. Nagaraja only talks about amusement, Milord. Doesn't talk about, Milord, culture, tradition, whatever. It says for your own amusement, you are doing this, that or the other, which is not permitted. And we are saying, Milord, it's not amusement, it's culture, breed, all that, Milord, I'm not repeating. But I want your Lordship to have a look, Milord, at, Milord, this M, subclause M, 11M, Milord. They just read M.
Yeah.
So, Milord, 11 will start one by saying, if any person, then we go to M. Solely with a view to providing entertainment. If he confines or does this, that or the other, or to incites or fights, etc., then, Milord, he will be punished. So, Milord, the offense is, you can have, Milord, sole amusement, but if amusement leads to subclause 1 and 2, then you will be punished. Take an example, Milord, of horse. I have a horse. I use it for riding. Not as a beast of burden. Not as, Milord, for agriculture purposes. Not like a donkey, not like a camel. I use a horse only for riding. That is pure, Milord, amusement. So pure amusement is allowed in M. Even if Jallikattu was to be pure amusement, without, Milord, falling in the clutches of these offences, see M, Milord.
Yeah.
Solely with a view to providing entertainment, if he does this, that or the other, Milord, he will be guilty. So, solely amusement, for sole purposes of amusement, is permissible.
No.
Kindly have a look. I'll read it.
If any person solely with a view to providing entertainment,
Yes.
does any of those things,
Correct?
then it's an offense.
I agree. But if he doesn't do all of those things,
If he doesn't do it, of course it doesn't.
correct, Milord. All I'm saying is, what I was trying to drive at is,
Mr.
if I keep a horse only for riding,
Mr. Rogi, just to test the proposition that you are
Yeah.
projecting before us.
Confines or causes
You are saying that
animal.
Nagaraja,
Next one. So
It
no,
talks
you want
about-
to make it object of prayer for any other animal then, and then only it will.
well,
So confining by itself will.
Then you have to meet also 11B.
But this one.
You see, it is like the sort of the other newspaper case. If you come to 11B, but
yes,
and you see,
Yes.
each of these clauses, duties are separate and mutually exclusive.
yes,
You take just read clause B.
yes, Lord. If any person employs in any work or labor or for any purpose,
All for any purpose. We are already concerned with that.
any animal, which by reason,
We can
that is,
skip all
Lord,
that.
a
Skip all that.
purpose other than work or labor.
Skip all that or other cause. Or other, see, we only want you to read
Or other cause, yes.
employs any animal for any
By-
purpose.
by-
if for any other cause is unfit to be so employed.
Yes.
So here what Nagaraja argues is that the animal in question, the bull, is not suited.
Yeah.
This is the thing.
That's yet another issue, Milord. That's yet another issue. That Milord specific type in the Maharashtra report, Milord, it is replete with this. That certain bulls and certain breeds can run and are meant to run, but are not meant to, Milord, wear the plow with maybe 50 kilos and do agriculture. While generally they are, and they would do that. Like an Arabian steed, Milord, would run, but would not drive a horse carriage. Things like that.
What is your answer to the argument? Because that's perhaps was the most central point going to be that when you let a bull into in a Tamil Nadu situation, surrounded by 13, 14 men, as they have now made, because if they participate, they've made
Yes, correct.
not one, many will surround.
Yes.
So the bull is traumatized. Past experiences has taught it a little bit. This is what I'm going to expect. So that in whatever little limited brain the animal has, it starts working, the chemical starts working. And the emotion of fear, this
That's what the judgment says.
Nagaraja argues
Yes.
that the fear is equal to pain. You put it like this, fear is equal to pain. Now the pain not relatable to any essential activity of the human being, as compared with, as captured in 11.3 A to E. All are needed. This is again, like you said, for entertainment, that is not prohibit what you said.
If you don't violate those subclauses.
So here, if it is not really suited, like for example, you are doing with the horse. Like we play with our horse, like
Yes.
with our pet dog. We do a lot of things with it.
Yes, sir.
But you stop where you cause pain to it.
Yes.
That is the central point, that fear.
Milord,
Nothing remains. We agree with you that after the rules, if the rules are properly implemented, the factual matrix of
that time, Milord, will go away.
knocked out. You're right there. We'll proceed with that. But then what happens even now?
Milord, with great respect.
What is your answer?
Yeah, Milord, answer is this. That is what the court found 8 years ago. And the last 4 years of 18, 19, 20, 21 and 22, 5 years, the animal board finds it the other way. Therefore, there is a sea change. Milord, from that time, because it's the same board on which the court relies in those 3 reports of 3 districts to, Milord, come down heavily on the state in 2013 and 12 or whatever. And today that report or their stand today is that 5 years, Milord, has had a sea change and that has disappeared.
One thing, now with respect to the construction of a 11.1M,
Yes,
see, with a view to providing entertainment,
yes,
then 1 and 2 are there.
yes, sir.
So unless those prohibited acts
My lord.
under 1 and 2
My lord,
are not done,
my lord.
the mere providing entertainment will not be a punishable thing. Is it the
Grateful,
contention?
grateful.
Is it
Therefore,
that?
I am saying that if Jallikattu,
That is the contention.
that's the contention. If Jallikattu is properly done in the form of those traditions which they had, with strict the supervision of the collector, I'll show to your lordship how it is done. It is not done in that. There is a very, very heavy supervision. I'll show you how it is done. Apart from the rules, what is the actual groundwork? Therefore, when that is done, and Jallikattu, can be done by an animal, I mean, anatomically, if I may say so. Then even if it is for amusement, rather than a tradition, the judgment proceeds on the basis that pure amusement, you are doing something and that is bad, but that, is permitted under the law. That was the only purpose of showing this. Now, 2-3 passages of the, I'm sorry.
One moment.
My apologies.
No, that's nothing to apologize. You have projected it on the basis of the duties of the keepers under section 3.
Yeah.
Now, you say that animals have no right. So therefore, no enforceable thing, obviously.
Yes.
That's what you are trying to say. Now, suppose somebody sees a particular animal being ill-treated by the keeper.
Right.
Can somebody not come and say that this animal is being ill-treated?
We can, and therefore,
Can we not therefore say that people who are before the court are actually saying that those who are supposed to keep the animals
are
safe
not keeping properly.
not keeping properly?
Therefore,
Can
yes,
this not be a
your lordship is right, but the answer would be to punish them for the offense.
no?
That's when go and file a complaint. Look, this man is my neighbor, and this is what he's doing.
No, that's okay. Punishment, yes, but then doors of the court or the mitigation forum is available.
No, my lord, it will not be available. Otherwise, we will not see how difficult will it become. One of the clauses, my lord, says, my lord, HCH, being the owner of an animal fails to provide animal with sufficient food, drink or shelter. How is it enforceable? What does shelter mean? What does drink mean? What does sufficient food mean? My lord, it's impossible. Therefore, in a given case, if somebody finds that an animal is being starved, he can go to a court and say he's starved, punish him. That's it.
But to that extent, the person can come. After all, what is he projecting? He's not seeking.
For punishment, yes, my lord.
Punishment, yes. Punishment, yes.
That's it. That's it. Cannot go forward to say these are statutory rights. Statutory rights will give duties. Duties will give 51A. 51A will give 5 freedoms. That's how the amalgam is grown.
He will not put it on that.
Right.
That punish him. So on the pain of punishment,
Yes, your lordship is right.
food will be provided.
I have no quarrel with that proposition. Your lordship is right. Now, my lord, see a few passages how the judgment, my lord, builds up this base of intermingling and this and that. My lord, your lordship will find. Go straight now. One. My lord, your lordship will find. My lord, I will go straight to. See, my lord, para 64. Before para 64, one thing I want to say. Let's just see 64, then I'll come back to one more parameter which I am missing. Come to 64 for a second. See another judgment. 64. See, my lord, freedom. Lord, 64 says guidelines of the World Health Organization of Animal Health, which is in 63.
Yeah.
Kindly turn to below page 590.
Paragraph 64.
Para 63 and 60.
Yeah.
Below 63 talks about World Health Organization of Animal Health, OIE, of India, of which India is a member, acts as the international reference organization of animal health. Now let's come to freedom. I'm straight away going to freedom. Chapter so and so recognizes 5 freedoms. Freedom not for animals, like freedom from hunger, threat, freedom from fear, distress, physical, thermal discomfort, freedom from pain, freedom to express normal pattern, etc. Now these 5 freedoms are now judicially imported into 3 and 11. Your lordship may see straight away. I'll pause here for a minute and go show to your lordship the direction. Kindly, my lord, have a look at the directions at page 601. See, my lord, for this purpose, 91.2. This is relatable to para 64. Kindly note that, my lord. Kindly note, my lord. Para 64 is relatable to direction 91.2. We declare that the 5 freedoms, sorry.
Yes, you.
This goes 601, 91.2. We declare that the 5 freedoms referred to earlier be read into 3 and 11 to be protected and safeguarded by the government. So a mandamus is issued by my lord reading these 5 freedoms for no real rhyme or reason into 3 and 11. 3 and 11, my lord, are not being declared unconstitutional, so that you have to read into something, you have to read down something, you have to uphold something. None of those clauses. Now, my lord, your lordship may now see 66. 66. Rights guaranteed to animals. Please, my lord, I'll read it slowly. 66. Rights guaranteed to animals. Lord Justice Ravi Kumar, 593. Rights guaranteed to animals under sections 3 and 11 are only statutory rights. I want to pause here for a minute. According to me, no rights are granted under 3 and 11. It's only an injunction on humans. And as my Lord Justice Zola put it, on the pain of an offense. That's it. This, my lord, is now read. See the next line. The same has to be elevated to the status of fundamental rights. Now, this country is struggling for enforcement of fundamental rights of individuals. When we come in 32, your lordship says go to the High Court. And we are struggling, people are struggling in this country, my lord. 32 itself is a fundamental right, but you say go to the High Court or wherever. Now, my lord, if you elevate this to fundamental rights, what is going to happen? Was it ever contemplated by the Constitution? So, my lord, the next line. Rights and freedoms read with 3 and 11 are read along with 51A, G and H, which is fundamental duties. So first you put in 5 freedoms, then you put in, my lord, the Constitution, and then you create, my lord, 3 and 11 as rights. With respect, each one of those steps is wrong. And therefore, my lord, last line, it says 51A, G and H is the Magna Carta of animal rights. So where do we get animal rights in 51A?
Mr. Ravi, whenever we have a duty, there is corresponding right.
In humans.
So the structure of duties,
That is also not
corresponding with rights.
my lord,
have
that
been
is also no, but that is also not absolute. Duties are there in 51, my lord. There is the right to enforce. So it is not, my lord, it's not, my lord, A is equal to B and B is C, therefore A is C. It's not one of those.
No, there is a difference because 51A right or duties.
Yeah.
They are not coupled with punishment in default.
Okay.
Whereas these duties carry a sanction that.
You know, they carry a sanction, so sanction will be applied. No problem. Sanction will be applied on the human because it is being made by humans. It will apply to humans.
Then what is really a difference between suppose you call this the right not to be maltreated.
Yes.
Why should it not?
No, there is no right to be maltreated. Put it another way.
Right not to be maltreated.
No, there is, it would not be a correct phrase. The phrase would be that the human being has no right to treat somebody. That's it. It is not a right vested in somebody else. Right? Because of this, it follows that I should not be maltreated. That's the error of the judgment. The judgment proceeds on the basis that if this is the duty of humans upon sanction of an offense, it automatically means that there is a right in the animal. And that right is intermingled with 5 freedoms and then intermingled with 51A. None of that, with respect, is a part of our jurisprudence. One more passage I left. Last lines of 64. With great respect, I should have read it. Last lines of para 64. They're very critical of those 5 freedoms. These 5 Placidum D, page 593.
Yeah.
These 5 freedoms, as indicated, are considered to be the fundamental principles of animal welfare, and we can say that these freedoms
That is at least right.
2 o'clock. 2 o'clock. Sorry to be.
There are infringement.
May request for 15 minutes, not more.
There are repeated respondents, blood.
Yes.
Couple of petitions.
Grateful, man.
Grateful.
Because may I just take a moment? Because the estimate on both sides is that it will continue today, 501.
May not. We have said maybe at least by half an hour we'd like to devote to.
All right, very well. Then
we want to begin.
No, very well, very well.
By 3:30.
No problem.
To your lordships would like to continue tomorrow morning?
Of course we will continue.
Tomorrow there will be some.
We'll be continuing. We'll not be breaking up the constitution bit. After this is over, we'll take up the Jallikattu.
Your lordship.
We'll just continue. The bench. No.
Grateful.
Tomorrow, there is another constitution bench, but there's the problem.
True. But then we will not break up this bench. That's all we are saying. Who wants to address this in Jallikattu?
But in any case, we have to address, Lord.
Lords, in this matter, we would like to respond after Mr. Sharma and Mr.
That's right. We are going. Let's see how we will get. Yes.
Grateful.
Well, let's kindly see the setup which has been explained.
Yes. But we'll just keep a time on this.
Well, I'll wrap up in 10 to 15 minutes.
Yes.
The commission has a separate secretariat at New Delhi consisting of about 300 officials in a hierarchical setup. 2 or 3 deputy election commissioner and the director general, who are the senior most officer in the secretariat, assist the commission. They are generally appointed from the national civil service of the country, are selected and appointed by the commission with tenure. Directors, principal secretaries, secretaries, under secretaries, and deputy secretaries support the deputy election commissioner and director general in turn. There is a functional and territorial distribution of work in the commission. The work is organized in division, branches, and sections. Each of the last mentioned unit is in charge of section officer. The main functional divisions are planning, judicial, administration, systematic voters, education, and electoral participation.
Treat it as read, David.
Yes. So one can take it that.
We are just noting it setup.
Yes, so there is a setup. Now, this setup linked with, if my lords can take the People Representation Act of 1950. 1950 People Representation Act.
1950 Act.
50 Act. The endeavor is to show how the statutory breakup of the administration of the entire exercise, going up to the last mile of declaration of result, and what is the involvement of the commission or the commissioner for that matter.
Just give us the sections.
Yes, I'll just give us.
So that you know.
I'll just give those sections.
Give a brief note if you don't know.
I'll certainly give that.
That will do. So we'll just notice as how the RP Act minimizes the importance of this is what we're trying to say.
Yes, the entire process is very, very independent. Different functionaries are allocated different jobs.
That's right.
Even this goes to the extent section 60 say, how do you declare result? No need of interference unless and until the election commissioner says that in absence of any direction.
So just give us those sections.
But I can
separate note. We'll make it give a note by. Well, we'll see.
I'll give the note, Malas, on this what is the scheme under the People Representation Act so far as the independent functioning is concerned. Yes, Malas. But the one judgment which my lords have seen numerous times, the MS give. Just one para of that I want to read.
Okay, paragraph.
Well, the last paragraph that is at. Well, my lords can take the compilation for a minute.
It just gives the drift of it. What is it? What is it?
Well, basically, there the request was made to the court that please make some guidelines so far as to build in the audi artem partem rule, where there is a dispute in the candidature of someone. You frame those guidelines. How the court reacted to it, let's kindly see that. Yeah, this is page 1384 of this.
1 minute.
I'm sorry.
Paragraph you have not given.
Well, I'll just give that. page 1445, para 130, 130.
Begin.
Yes, please. Being not altogether certain of all the facts and circumstances that may be made available in the appropriate forum, it may be a premature exercise by this court even to lay down guidelines when there is no hidebound formula of rules of natural justice to operate in all cases and at all times when a decision has to be made. Justice and fair play have often to be harmonized with the exigencies of situation in the light of accumulated totality of circumstances in a given case, having regard to the question of prejudice, not to the mere competent in an electoral contest, but to the real and larger issue of completion of free and fair election with the rigorous promptitude. Not being adequately informed of all facts and circumstances, this court will not make the task of election commissioner difficult and embarrassing by suggesting guidelines in a rather a twilight zone. Well, that's what I'm saying, that the court was very, very guarded in this, in spite of, and interestingly, in this particular dispute, court said they should be heard. So even that was in which year? 1978. Yes, the 44 years ago. December 2, 1977. Yes, Yes, then. Well, the one more, just one para in that, the 1986 4 SCC, page 78, para 15. There the prayer was made that the appointment method of election commission be equated with the judges. Court said refused. That's the, I think, that was refused in that case. That was refused. 86 or 96? Well, this says 86, 1986, 4 SCC, page 78, and para 15. Yeah. Well, as if I summarize what I wanted to point out was, but the first is my humble submission looking at the scheme which has been there right from 324, 324.5, respective law being made, people representation being there. This is a scheme in itself, even if looking at the Constitutional Assembly debate in terms of reading the mind of the constitution makers. There is no vacuum which today... No vacuum. Yes, that's the first submission I have. Second submission is that why subject to law has been put in 324.2, noting the background debate on that aspect, is that the freedom has been given to the parliament with the test of time. What is the time and what is the stage and what is the event should be the time when this should be exercised. Before that, the process which has been provided, if that process has got any error in terms of functionality of the commission, then this court is there to look into it and has been corrected on a numerous occasions. Therefore, this not is going to mandate to say that, well, if this argument would have come in 1960, assuming for a minute, and this would have been looked at from the point of view, say, no, you please frame a law in 1960, a law should have been framed. That could have been there, and today the situation. And with walk of life, I don't think the society is going to improve. The distrust and mistrust is going to increase by virtue of integration it has emerged in the society. So there can be a different features today we may not be even contemplate. And like in that privacy judgment, Justice Nariman said that so far as at the constitution making stage, the privacy would have been a very different meaning. Today, with the technological developments, it has completely gone into a different realm. Even in terms of a location, geographical jurisdiction, nature, simple comment. So contemplating that these are the changing dimensions which will come. And underlying fact is that today there is no pointed fact which requires that some correction is there. No trigger point. That's the third thing which I want to point out. Fourth is that the test of Vineet Narayan or test of Vishaka which has been sent, two fundamental factors which are extremely important. One is there was a trigger. Second, there was a consensus where the union also was wanting that since there is a vacuum of any statute existing and not going to the umbrage of constitution to say that there is some method has been given. In that, even both the parties sat together. That may be IRC report, or that may be Vishaka Para 16, where it has been taken to note that we both agree that this is the area which is to be done. Third factor, which is important in this case, is those are the cases which are to be tested to the extent of violation of 21. So we are going to pitch, and those are the individual rights which are created. Today also one argument can be that the